Hello, today we have with us Mr. Amit Sibal, Senior Advocate, Supreme Court of India. Thank you so much for joining us, sir. So we are very delighted to have you on our channel after the amazing session that you just conducted about anti-arbitration injunctions. So sir, coming to arbitration as the topic here at the conference, so what would you like to comment upon the effectiveness of arbitration vis-a-vis court proceedings and court adjudication?
In India, I don't think we have a choice. We have to promote arbitration because of the pendency of cases in the civil courts. We have a pendency of almost 50 million cases across courts in India. So I don't think we have the luxury of deciding whether arbitration is the need of the hour. It clearly is imperative that we have much more of arbitration than even we have today. And just in a lighter vein, today a practitioner like me, the only experience you have of complete trials in the practice of law for a counsel in India is in arbitration, because the duration of suits is such that it's only in arbitration that you have the opportunity to see a case through from the commencement of pleadings to cross-examination, oral evidence, to arguments on interim injunction and merits, and then the closing arguments at the end, all within a manageable time span of about a year. And that is a telling fact about the jurisprudence in India and the system, where a counsel doesn't get the experience of all of this in any reasonable time frame in court.
Right. So even though there are a lot of advantages of arbitration, but we still see there's a little bit of hesitation amongst people to go towards arbitration rather than courts. So is there any specific reason for that?
I think people feel that a number of things. Number one, people are hesitant because they feel that the opportunities to challenge are constricted by Section 34 of the Arbitration Act. There are issues that arise about costs in some cases. Ironically, though arbitration was conceived originally as something that was more cost effective. But equally important, I think people are concerned about integrity in some cases of arbitral tribunals. And if there is a concern about integrity and you're faced with a challenge in the narrow confines of Section 34, then some people have difficulties. But I think there is an answer that is on offer in India, and that is institutional arbitration. I think if institutional arbitration clauses are incorporated in contracts, our institutions are vetting the arbitrators, there's a track record to look at, then I think that a lot of these concerns, including the cost effectiveness, can be addressed, especially with some of the larger, bigger ticket arbitrations.
So coming to integrity, there are sometimes questions on integrity of judges also, but still people trust courts more. So any comment upon that?
When you say people trust courts more, you mean comparative to?
Arbitration. There is some hesitance with arbitration, maybe because of cost also, but like you mentioned, integrity.
I'll tell you the difference is that in courts you have an appellate ladder where you have full scope of appeal. But in arbitration, the scope of appeal is limited under Section 34 only to grounds that the arbitral award is against public policy, or where you've not had a chance to present your case in the arbitration proceedings, or there is fraud or corruption. But other than that, and these are fairly narrow grounds, the appeal against an award is limited, whereas the appeal in court is a full-scale appeal. But on the other hand, is going to take years and years, and the outcome may not see the light of day even in an individual's lifetime.
So now coming to anti-arbitration injunction, do you think that these are fundamentally at odds with arbitration law?
Anti-arbitration injunction, you might say, challenges some of the fundamental principles of the law of arbitration, namely minimal interference in arbitral process, and you're asking a court to interfere by granting an injunction against that process. The principle of party autonomy: if parties have indeed agreed to have their disputes settled by arbitration, then why should a court pass an order that would entail a breach of that agreement by one of the parties? and the principle, of course, of competence, which is that if there's an issue on jurisdiction, then the arbitral tribunal has the competence to deal with issues of its own jurisdiction under the New York Convention and as implemented in the model law and also in the various arbitration statutes across various jurisdictions, including India. But what if you have an exceptional situation where the arbitration is yet to commence and there is no arbitration agreement at all with a party, but that party is sought to be forced into an arbitration proceeding? What if there are serious issues about the integrity or the constitution of a tribunal? There can be various situations where a court might, on those specific facts, conclude that an anti-arbitration injunction is merited. But it has to be only in exceptional situations. The rule must be that by and large the arbitral tribunal or the courts of the seat where the tribunal is seated will decide the challenges in accordance with the law of the seat. The scope for going to a different jurisdiction to get an anti-arbitration injunction should be very limited, because ultimately commercial actors are looking for certainty, predictability, and the preservation of the choices that they have made. And if that choice is to settle the dispute by arbitration, then the courts would should by and large, respect that choice that the parties have made. Having said that, there is the other side of the coin where you have a situation where, as we were speaking about on the panel as well, where you have a manifest abuse of process by a party. For example, an attempt to use an anti-arbitration injunction to undermine an award that has already been passed, which has happened in certain cases. Courts all over the world have, in exceptional situations, considered and granted anti-arbitration injunctions in those cases. And ultimately, if you don't have the ability to get an anti-arbitration injunction in those cases, some would argue that that goes against the very principle of party autonomy, because parties make choices, for example, to have a proceeding which is decided impartially by an arbitral tribunal. And if that is fundamentally undermined by an issue that goes to the root of the matter, then in order to promote that very party autonomy, a court might legitimately decide in an exceptional situation to grant an anti-arbitration injunction.
Thank you so much, sir, for joining us.
Welcome. Thank you.